All right, good morning. Thank you so much for joining me today. Today, we are going to talk about Social Security disability claims for plumbers. And before we get started, I do want to make sure to note that today's webinar should not be considered legal advice. It's just a little bit of extra background on Social Security disability claims for plumbers. If you are on the live webinar with us, you'll notice I won't take any questions at the end. And if you're watching the recording, I won't respond to any questions posted in the comments. And the reason for that is because I can't give legal advice based on just a little bit of the situation. So if you do have questions specific to your situation that you would like addressed with respect to your Social Security claim, I'll put my contact information at the end of the webinar. Feel free to please reach out, ask any questions. If I can't help you, I'll try to put you in touch with someone who can, but I don't do kind of respond to questions live or in comments. And that's the reason behind it. Legal advice is so specific to unique situations. Everybody's case is a little bit different. So knowing that, I won't do questions or respond to questions, and I apologize. But as I said, I do provide contact information at the end of the webinar. So if you do have questions about your specific situation, reach out. If I can help you, I absolutely will. If I cannot, I will try to put you in touch with someone who can. All right, with that out of the way, when I do these webinars, I always kind of do them in a specific order. I will do first, we'll cover some Social Security disability basics, give you a little bit of an understanding of how the program works. Then we'll move into residual functional capacity. And then today, because we're talking about plumbers, which is typically kind of heavy type work, we'll talk about the grid rules. We'll talk about some special rules that might apply. And then finally, how an attorney can help you with your Social Security disability claim. Before we get started, a little bit about me. My name is Kaitlin Wildoner. I'm the founding attorney of Beacon Disability PLLC, which is a law firm based in St. Johns County, Florida. And through that, I exclusively practice federal administrative disability law, which means I handle Social Security disability insurance and supplemental security income cases at the initial level through the appeals council stage. Okay, so a little bit about the programs. When people apply for Social Security disability, they don't always understand what they're applying for, what it means, what's going on. They just know that they're hurt and they need help. So there are two different programs that you might qualify for if you've applied for Social Security disability. There's Social Security Disability Insurance, SSDI benefits, and there's also Supplemental Security Income, or SSI benefits. Both programs require that you be disabled and unable to work for a period of at least 12 months due to physical and/or mental impairments. Now, you don't have to be disabled for 12 months before you apply. If you get into a car accident in January, it doesn't mean you have to wait all year before you can apply the following January. What it means is if you get into that car accident in January, the conditions and limitations that you sustain as a result of that impact will last for at least a year. So you can apply as early as January. You can apply the day after that car accident, as long as those conditions are going to or are expected to last at least 1 year. Okay. So if that car accident, if you're expected to be back up and running back to normal by March, then Social Security is not going to be an option. But if it's looking at least a year of disability, or if you do already have that year in the rear view, if you got into an accident last January and you still haven't applied and you're still not able to go back to work, you're still not able to function on a daily basis as you would like to, as you normally would, that's where Social Security comes into play. Okay, so both of those programs have that same requirement that you must be disabled and unable to work for at least 12 months. Now, where they differ with SSDI benefits, those benefits, the monetary amount that you'll receive each month is based on what you have been able to pay into Social Security while you've been able to work. So you must have sufficient work credits to qualify for SSDI benefits. For SSI benefits, on the other hand, that is more of a welfare program, and it does have income and asset restrictions that you must be below. You don't have to have a work history requirement. You don't have to have any of that. But for SSI, you have to have below a certain threshold of income and assets. And generally speaking, that asset threshold right now, as of the recording, is $2,000 if you're single and $3,000 if you're married. So the assets, if you have over $2,000 in assets and you're single, you won't qualify. If you have over $3,000 and you're married, you won't qualify. There are a lot of exclusions to that. Generally speaking, that asset threshold will include any bank accounts, retirement accounts, investment accounts, things like that. There are other surprising inclusions. It does not, however, include one home and one car. So you can have one home that you live in and one car that you drive, and those do not count towards that $2,000 or $3,000 threshold. However, if you have two pieces of property or two vehicles, or you don't live in your property, different rules apply. With multiples, if you got two properties, two cars, those do count. The second vehicle and second property counts towards that asset threshold. So that's the basics. The 5-step evaluation process is how claims are evaluated. When you file your initial application for SSDI or SSI benefits, your claim gets processed through this 5-step evaluation process. When you first submit it, Social Security gets it and they look to see, number one, are you engaging in substantial gainful activity? Do you have substantial gainful activity that you are currently engaging in? If you are working more than 20 hours a week or earning more than $1,350 a month in gross earnings, so that's before any deductions, you are considered engaging in substantial gainful activity, and your claim will be, your claim will be denied based on that. Okay, I usually have 3. I don't know where the other 2 are. All right, so if you are engaging in substantial gainful activity, Social Security doesn't even look at your conditions. They don't go any further. They say, well, it doesn't matter what you have going on because you're able to engage in substantial gainful activity, and therefore you cannot be found disabled by our definition, okay? If you are not engaging in substantial gainful activity, Social Security moves to step 2, which is, do you have one or more severe medically determinable impairments? If you do, then they will go to step 3. If you do not have any severe impairments, Social Security will say you can't be disabled because you don't have any severe impairments. All right, so assuming you do have at least one severe impairment, then it'll go to step 3, which is, okay, using that severe impairment and any other conditions that you have going on, do you meet or equal a listing? If you don't, then Social Security will keep moving. If you do, and you do meet or equal a listing, Social Security will approve your claim and say you are disabled because you meet listing 14.02, whatever it is, okay? If you do not meet or equal a listing, then Social Security moves to step 4, which is, can you go back to your past work? So what they'll do in making that determination is they create a residual functional capacity, or an RFC. And we'll get into that a little bit in a minute. But what that is they determine what you are capable of doing based on your medical records. So they will say, okay, you can stand for 6 hours in an 8-hour day, sit for 6 hours in an 8-hour day, lift and carry 20 pounds occasionally, 10 pounds frequently. So basically you're limited to kind of a modified light residual functional capacity. What was your past work? So here today, we're talking about plumbers. At a modified light like that, you're not going to be able to go back to your past work as plumber. So what will then happen is Social Security will look at and see, okay, you can't go back to work as a plumber, but can you engage in any other work? And that's step 5. If you can go back to your past work at step 4, then you're found not disabled. If you cannot go back to your past work, Social Security looks at that RFC and they say, okay, could an individual with this age, education, and residual functional capacity and your past work as a plumber, can you go back and engage in any other type of work? Okay. And that's where kind of the grid rules will also come into play. There's a lot that comes into play here, especially for plumbers, because typically plumbers, that's a little bit, heavier duty kind of work. All right, so here are the different residual functional capacity categories. As you'll see, there's sedentary, light, medium, heavy, and very heavy. At sedentary, you would be expected to lift no more than 10 pounds ever, and you would be required only occasionally to walk or stand. At the light exertional level, you can lift and carry up to 20 pounds occasionally, 10 pounds frequently, and you would require frequent standing or walking. At the medium level, you can lift and carry up to 50 pounds occasionally, 25 pounds frequently, and again, that frequent standing and walking. At the heavy and very heavy exertional levels, those aren't super defined. It's just greater than medium. And very heavy tends to be over anytime you've got to lift over 100 pounds. So not, again, not set in stone, not concrete, but just typically, often my experience has been kind of thing. Okay. So those are the different RFC levels. And again, these are created from Social Security based on your medical records. It can also be helpful if you have a supportive doctor for her or him to put in the records what you are limited to. And it's important to just, that they don't just put light work, because as you can see here, this is Social Security, what they consider to be light work. In some situations, light work, especially if you're used to being a plumber, might be sedentary. That might be what the doctor has in mind, is you're sitting there and you're sorting the different fixtures and tools that you can just use your hands with that aren't super heavy. They might really tell you that you can do light work, but it's really, as far as Social Security is concerned, defined as sedentary. So it's important that if you've got a supportive doctor, that they indicate not just what level you are at, but what that means. Okay, if they say you're limited to light work, can you lift up to 20 pounds occasionally and stand pretty frequently? Or is it more sedentary, where you need to be sitting most of the time and really only lifting, office supplies, things like that? So that's important. And it may be you can't lift anything. Have them put that in the record. That can be very, very helpful. The RFC will often include, in addition to standing, sitting, walking, lifting, carrying requirements, and abilities, I should say, not requirements, it will also include other abilities that you've got. Your ability to climb stairs and ramps, your ability to climb ladders, ropes, and scaffolds, your ability to bend, stoop, kneel, crouch, crawl. Your ability to, getting into the more mental impairments, includes things like, are you limited to unskilled work? Can you interact with others? Can you frequently interact with supervisors, coworkers, and the public? Are you limited to simple, routine, repetitive tasks? Are you limited to simple work-related decisions? Are you going to be off task at all during the day? Things like that. The RFC is all-encompassing. It includes physical and mental impairments and limitations. And it's important that if you have a doctor who's telling you what your limitations are, that they don't just tell you, but they actually put it in the notes as well. We see that time and time again, unfortunately, where some doctors will say to the patient, okay, you need to be lifting your legs heart level, for 30 minutes in every hour. Okay, well, that's a huge limitation. If your doctor's telling you that, they need to also put it in the chart. So that way, when Social Security or your attorney goes to request those records, that's in there. And Social Security can see, okay, they're not just saying that, their doctor did recommend that, did advise them, did tell them to do that. Okay, so if you've got a supportive doctor who's telling you things that you shouldn't do, please, please, please make sure those limitations are in the chart. Okay. Going to some RFC tips, like I said, have your doctor either complete an RFC form that outlines your limitations, or just ask them to put those limitations in the record. It does not have to be anything fancy. It does not have to be on a special form. It just has to be in the record. It's also helpful if your doctor says why those limitations exist for you. So not just, okay, Mr. Jones can only stand for 20 minutes at a time in an hour total in an 8-hour day, and he can only sit for 30 minutes at a time in 4 hours in an 8-hour day, and he can only walk for 5 minutes at a time for 30 minutes okay, that's super helpful, but why? What happens after you sit, stand, walk for longer than those prescribed times? What is causing that pain? Is it the back? Is it the hips? Is it the legs? What is it? What is creating those limitations? It is not enough. And I have this conversation at least once a month, usually more than that. It is not enough for your doctor to say that you can't work because of your condition. Just having a doctor say you are disabled, you cannot work. You cannot work because of your condition. Social Security doesn't have to take that and say, okay, well, we must now find you disabled. Social Security considers disability and inability to work to be an issue reserved for the commissioner. So just having a doctor say you're disabled and unable to work, and even putting that in the chart, while that can be helpful, it's not as helpful as if your doctor can put in there why you're disabled and unable to work. What limitations do you have that are preventing you from working? Are you unable to sustain a standard 8-hour day, 40-hour work week? Why? what are those limitations that are there? So that's kind of, it's more helpful if a doctor can get more specific about why, instead of just saying, nope, you're disabled, not able to work. Yes, I'll put that in the record. Okay. All right, so because we're talking about plumbers here, we are going to cover some of the grid rules. If you are a former plumber and you are limited to sedentary work and you are between the ages of 50 and 54, this first set of lines up here is applicable to you. So you would want to look at that third column there, which the first row says limited or less. That's talking about education. So if you have less than a high school education and you have some skilled or semi-skilled past work with non-transferable skills, you would be considered disabled by Social Security. If you are 50 to 54, limited to sedentary, and you have a high school degree and you cannot make a direct entry into skilled work, and you don't have any transferable skills, again, disabled. At light, if you are limited to light work, 50 to 54 years old, and you are either illiterate or unable to communicate in English with unskilled past work, which is typically not plumbers, that's where you're disabled. So unfortunately for plumbers, oftentimes between 50 and 54, if you're limited to light, that's not an automatic gridding out, okay? Just because you can't go back to your past work as a plumber, there's still other work that you can likely adapt to. And it depends very much on your specific situation, but there might be other jobs that exist. Okay, so that's not enough. Now, when you get to 55, it gets a little bit easier. As you can see, there are the top bars again are sedentary and the low are light. And as you can see here, sedentary largely kind of follows the same path as before. And light here, it will bump you up to disabled if you cannot go directly into skilled work and you don't have transferable skills. So that's where, you might hear, especially if you call our office, you'll hear, okay, well, how old are you? You will have this discussion with you, because if you're 55 or older, it can be a little bit easier if you've got supportive evidence to show that you're limited to light or less, that you should be found disabled. And then here's, of course, 60 and above, and this is at medium work. So it's if you still can go back to medium work, then unfortunately, oftentimes Social Security will say that you can go back to your past work. You can go back to your medium level work or something a little bit less strenuous than what you're used to, but still pretty physically involved. Okay, so here are some special rules and medical vocational profiles. The top, neither one of these really apply to plumbers, but they can apply to, some plumber assistants and things like that. So if you have only ever done arduous, unskilled physical labor, so again, not plumbers, because plumbers, you guys have some skills. If you have no more than a marginal education, so if you've got a 6th grade education or less, and you've got 35 or more years of work experience doing only arduous, unskilled physical labor, and you are not currently working and you are no longer able to do that type of work because of your severe impairment, Social Security should be able to consider you unable to do lighter work and therefore be found disabled. That's the worn out worker rule. So again, that doesn't really apply to plumbers. You might hear it thrown about, talked about, and you might think, okay, well, I've done, hard work for 35 or more years. Yes, but it's not unskilled. So that's the important thing to note, is the worn out worker rule. And that's why I included it in here. If you've got colleagues that did the unskilled work and are now unable to, this might be, a helpful tip for them. But in your situation as a former plumber, the worn out worker rule does not often apply. Also, if you are at least 55 years old, have no more than a limited education, which is less than a high school degree, you have no past work experience. Okay, so this is, again, not a plumber, unless you were a plumber 20 years ago and you haven't worked since then, and this is an SSI only claim, then this might be workable. If you have a severe medically determinable impairment, if you're 55 or older, you've got that limited education, and you have no past relevant work experience, then Social Security finds you to be disabled. And if the evidence shows that you meet that profile, Social Security doesn't even look to your residual functional capacity. Okay, so here you go. Here is the Dictionary of Occupational Titles definition for a plumber. And as you will see, it is considered a heavy job. It's right there under strength H. And then if you go over a little bit more, you'll see SVP 7, which is a skilled job. So as you can see, that is the definition of a plumber, assembling, installing, repairing pipes, fitting, fixtures of heating, water, drainage systems according to specifications and plumbing codes. And then it continues to go on to more that you do. So that's just here, just so you can see. But it's as you can see, it's heavy work, and I don't have to tell you, and skilled work. Okay. So now as we come to our close, how can an attorney help you? We can provide guidance on what correspondence from Social Security actually means. We file necessary appeals, we review your medical records in your case file, we discuss what additional records might be helpful for your case. And we do that with pretty much every case that comes through us. We talk to you about what additional records would be helpful. If you have supportive doctors, what the RFC we think would be based on the records, for you to mention to your doctor to see if it's something that matches up with what they agree with, and what they've told you. And oftentimes that will happen, if after I read the file, I call my client and I say, hey, look, it looks like you're limited to this kind of work. And they're like, yeah, that's exactly what my doctor said. I'm like, okay, well, your doctor hasn't said that in the records yet. I'm reading between the lines. Have your doctor put that in the chart. If that's what they've told you, put that in the chart. That can be helpful. Similarly, we review your documents for accuracy and completeness. That's not just your medical records, but that's also the function reports that you fill out, the work history reports that you fill out, especially if you're 50 and 55 and 60. The work history report is critical because it's going to determine what your past work is to determine whether you have transferable skills. And as we talked about in the grid rules section, transferable skills are important. If you have them, then likely you're found not disabled. If you don't have transferable skills, then you might be able to be found disabled. So it's important to have an accurate and complete work history report when you're 55 and up. When you get those forms, we can help you understand what Social Security is looking for. We don't fill them out for you because we're not in your shoes. We will never know what it's like to live a day in your shoes. When we read these forms, we can have an idea and it helps us better advocate on your behalf, but we don't know what it's like. So we are happy to kind of give you a broad overview. We're happy to take a look at it with you and chat about it afterwards. But by and large, we do ask for you to fill those out because it is your I like to call it testimony without having to go before a judge. So you're not under oath, of course, but anything you submit back and forth to the agency should be truthful and honest. You don't ever want to get hit with a fraud claim. That is not fun. So we can help kind of give you some guidance on what Social Security is looking for in those forms. Again, we don't fill them out, but we are happy to take a look at them and discuss with you what they're, kind of looking for. We also work with you to provide relevant updates to Social Security throughout your claim, and we provide them back to you. When we get an update from Social Security, if we hear from them, we will reach out to you and let you know. We've got a client portal that will just shoot you a quick message and say, hey, just so you know, just spoke to this person, they might be calling you. Just so you know, just spoke to this person, they might be setting you up for an exam. Just so you know, just to keep you in the loop. If we have to go to a hearing, we help prepare you for that administrative law judge hearing. And we also ask questions of you and any witnesses during that hearing. That is not all encompassing of what an attorney can do. We can do quite a bit more than that, but these are kind of the biggest pain points that I've noticed in clients over the years, and to kind of make sure that everybody understands, what does an attorney do to help? So we can be a great resource to use. We can be very helpful. Happy to help. All right. So as promised, since we don't give any answers to questions or anything like that, here is our contact information. Call, email, reach out to us. We are always happy to answer any questions that you've got. And, like I said, if it's not something that we can help with, we can point you in the right direction as to someone who can. It's never a waste of time. I would always rather you know what's going on and know, that you feel confident in what you're doing. And so always feel free to reach out, call, email, reach out. Thank you so much for joining this morning. If you joined us on the live, if you watched all the way to the end on the recording, thank you for sticking around and sticking through. Like I said, I won't answer any questions on the recording either, but please feel free to reach out. This phone and email address is there for anybody that's got any questions. Happy to answer questions, happy to help. There's also a link below where you can request a call from us on the recording. So it's not on the live, but on the recording, if you're on live, we can send that in the post webinar email, but you can schedule a call with me as well. And I'm always happy to answer any questions there. So again, thank you so much for joining. I hope you have a wonderful day. Bye-bye.